A very warm good morning to all of you. Dear students, once again I would like to welcome all of you to a new session of the Civics class. Today we are continuing with the same chapter number 4, the Supreme Court, part 4. Do you remember what we were discussing in the previous class? In the previous class, we were discussing about the different writs or important writs which can be issued by the Supreme Court. And what was the purpose or what are the benefits of issuing writs? The writs are mainly standing for enforcement of rights. Suppose if a person or government or any agency violates your fundamental rights, then you can approach the court and the court will issue writs by which you will get your fundamental rights. Okay, and there were 5 different important writs. First one habeas corpus, second one mandamus, third one writ of prohibition, fourth one writ of certiorari, and fifth one quo warranto. So these were the 5 different writs which can be issued by the Supreme Court. And today we are going to discuss a new topic, and that is jurisdiction and powers of the Supreme Court. There are some special powers vested with the Supreme Court. What are they and what is meant by jurisdiction? These are the different things or different points which we are going to discuss in today's class. First of all, we will be discussing what is meant by jurisdiction. Jurisdiction is the power that a court of law exercises to carry out judgments and enforce laws. So some special power given to a judiciary or an institution, and by which they can exercise to carry out judgments. And just carrying out judgment doesn't mean that it is completed. They can give the judgment and by which they can enforce laws. So that's what is meant by jurisdiction. Jurisdiction is the power that a court of law exercises to carry out judgments and enforce laws. Supreme Court is the protector and the final interpreter of the Constitution. So only Supreme Court has got the power to interpret the Constitution, interpret the different laws which is discussed in the Constitution. That way we can say that Supreme Court is the protector of the Constitution, because Supreme Court only have the permission to interpret the different rules and regulations according to the Constitution. So this is what is about the jurisdiction. The jurisdiction has got mainly divided into 3, and the first one is original jurisdiction, second one appellate jurisdiction, and third one advisory jurisdiction. Though there are 3 different jurisdiction, one more jurisdiction is there, that is revisory jurisdiction. So altogether we can say that there are 4, but mainly there are 3 different jurisdictions. Okay. So in the upcoming class, definitely we will discuss about what is meant by revisory jurisdiction and what are its importance. First of all, we will be discussing about these 3 different jurisdictions: original jurisdiction, appellate jurisdiction, and advisory jurisdiction. So let's see one by one in detail. First one, original jurisdiction, which means the power to hear and determine a dispute in the first instance. We are not permitted to go to any other, or we need not to go to any other subordinate courts, including High Court, for solving certain cases. So those kinds of cases are being considered as original jurisdiction. So directly we can move to the Supreme Court for getting justice. In other words, normally if there is some problems between some people, some organizations, some institutions, or even with the government, we cannot directly go to the Supreme Court. We have to file the case in the lower court, and from there we have to go to the higher one, and from there we have to go to the High Court, and from High Court it will go to Supreme Court. So we are not permitted to go to Supreme Court directly. But the cases which comes under original jurisdiction, we can directly move to the Supreme Court for getting justice. That what is meant by power to hear and determine a dispute in the first instance. The first appearance itself, we can file a case in the Supreme Court. Those kinds of jurisdiction is known as original jurisdiction. like those cases which cannot be moved in any court other than the Supreme Court. There are certain cases which will be discussed only in the Supreme Court. Let's see what are the different cases like. First one, center-state or interstate relations disputes. Center-state or interstate disputes. How? Let's see its explanation. The Supreme Court has been given exclusive original jurisdiction in any dispute between Government of India and one or more states. Suppose the central government and one of the states of our country. If there is an issue, it will be discussed only in the Supreme Court. Second one, between Government of India and any state. Okay, so in one side, first one we were seeing between Government of India and one or more states, which means in one side there is central government, on the other side one state or number of states. Second one, between Government of India and any state. And thirdly, state on one side and one or more states on the other. Suppose just a dispute between two different states. In one side there is one state and on the other side one state or more than one state. And finally between two or more states. So these all are. So generally we can say that if there is a dispute between central government with the state governments or state governments between state governments, those cases will be discussed only in the Supreme Court, not even in the high courts. So that is meant by original jurisdiction. Those cases will be only discussed in the Supreme Court. There are some exceptions. In this jurisdiction shall not extend to. Okay, this jurisdiction cannot extend to certain situations. That's what is meant by exceptions. First one, a dispute arising out of a treaty, agreement, etc., which is in operation. So suppose just imagine if there is an agreement between two states, okay, and there was a problem on the particular agreement or treaty which is already inactive. Already that agreement or treaty is active. Suppose there is an agreement made between two states for 100 years. So first 50 years there were no problems, then the problem started between both the states. So already the agreement or the treaty is in operation. So in such cases there are limitations for the Supreme Court to get involved in such kinds of issues. Second one, in certain other matters such as interstate water disputes, matters referred to the Finance Commission, etc. I hope you might be remembering, Finance Commission is being appointed by the President. So in such cases, there are certain limitations to the Supreme Court to get involved. Then again, interstate water disputes. There are disputes between a few number of states or between two states. In such cases, there are certain limitations to the Supreme Court to get involved. And third one, adjustment of certain expenses and pensions between the union and the state. Union government has granted certain fund to the states or to the union territories or to some agencies. In such cases, adjustment of certain expenses. In such matters, the Supreme Court cannot simply get involved in. Certain limitations are there with the Supreme Court. So these are the factors or elements related to the original jurisdiction. I hope that you have got a very clear idea about it. So with this, we are winding up today's class. In the next class, we will be continuing with the remaining points of the same original jurisdiction. So till then, I would like to sign off. Thank you.